events like this, I always enjoy doing them. So any questions you have, I'm happy to field. I generally talk about items that I consider to be fundamental to estate planning. And so if no one has any immediate questions, I will start addressing those topics. And yeah.
I have a question.
Certainly.
I had a will done when my mother was still alive, and did not, until I went through all of the things that we had to with her, I wasn't aware that I hadn't really, I didn't know everything I needed to know. And my question is about the executor.
Sure.
Is that a separate contract?
Yeah. So what I'll do tonight is we can talk about things in general terms and general principles and so forth. Because I don't know anyone's specific circumstances, I don't want anyone to go running out and take any action based on what I'm saying, because we're just talking general concepts and I don't know anything about your specific situation. But generally, if we look at a will is kind of the most common estate planning document that people are familiar with. And we see them in movies and television shows, and most people start with a will. And that's the document that you prepare to have your assets passed to your beneficiaries at your time of death.
But there's two different kinds of wills.
Well, the will that does that and takes your assets and passes them to your beneficiary is the traditional will, the will that passes your assets at death.
Okay.
And that's where the executor comes into play. When you die, or when you create that will, it sits there on the shelf or the safety deposit box and does nothing. Hopefully for a long time, long time, right? Because during your life, a will do nothing. But in that instrument, there's a position called an executor or a personal representative. And when you die, it's that person's responsibility to march down to the courthouse and say, hey, I would like to file a petition because the person who created this will passed away, and now we want to start the probate process. So that's a position you put right into the will.
But mine was not put in the will, and now I want to change it. That's
Okay.
my problem.
Yeah.
I now realize I can't put my 4 kids in as executor because somebody has to be in charge.
Okay.
And that's the part I need to get arranged.
Sure. Well, the good news is with a will is you can amend it at any time during your lifetime, and if there's a provision that needs to be inserted, you can insert it or redo the whole will in its entirety.
I don't really need the will redone, I just need to appoint one of my children, and I have already had the agreement with this person that they want to do it, and they will take care of it. So is that all that I need to do then, is just change that part?
Assuming that that's the only...
It was in a separate bunch of papers that I got.
No, I haven't seen the documents, but assuming what you've told me is accurate, then it seems that you could probably just make a codicil or an adjustment to that will, an amendment, and then have it completed following the formalities and have that work. Yeah, but you want to follow the appropriate process, but it seems like it'd be relatively straightforward.
I think so.
Yeah. And so that's usually what I start with, is the will and how that will operates. So unless there's any questions, I'm going to move on to a trust.
What's the difference in between that and a living will?
Yeah, a living will is a healthcare type document. That's kind of the pull the plug scenario when someone's not doing well. So the will, the traditional will, passes our assets at death. The living will says to the physicians, hey, if I'm not doing well, and we know I'm not going to make it, and the doctors say I have no chance, I'm going to pass and it's only a matter of time, or I'm in a permanent vegetative state, what do I want to happen? Do I want to be on life support? Do I want feeding tubes? Do I want to be kept alive as long as possible? Or do I not want a feeding tube? Do I not want those extra measures and just to go natural? That's what the living will does. It's more of a healthcare instrument.
So then what's the difference in between that and power of attorney for healthcare?
Yeah. The way I like to think of it is the living will is when you're not going to make it. You're not going to make it. That's your final wishes for the pulling the plug. Whereas the healthcare power of attorney, you could just be unconscious, you could not be well, you might be in a car accident and just unable to make decisions. Generally a shorter time period, but under the living will, it's your message to the doctors. Hey, this is what I want if it's the end.
Okay.
Make sense?
Yep.
Does that mean you have to have both?
A good plan should have.
One plan might include both, right?
Yep. Yep. Yes.
Do you need a will?
It depends on what you're trying to accomplish.
Everything between my wife and I, everything's jointly, and we pass away. If I pass away, it goes to my wife, and when she passes away, it goes to my two wives. And they're on all our accounts, DOD, and our home is a transfer.
So there's alternative ways to a will, right? When we look at a will is a tool, right? And so what we generally advise people, whether it's a will or a TOD or a trust, it's like building a house. And if you try to pound in nails with a screwdriver, you're gonna have a problem. So what you need to do is analyze your situation and say exactly right that. Do I need a will? What am I trying to accomplish here? Or does your TOD do it? And if that accomplishes everything, then you may not need a will at all. Or maybe you need to look at a trust or some other instrument. But if your situation is all resolved with TODs, that can be a very useful way of planning.
Thank you.
What else we got? Anything?
One question, what would be the advantage of a family trust?
Yeah, all right, so here's the transition. So when we talk about that will that sat on the shelf and does nothing until someone passes, and then someone takes it down and starts that probate process. That's the kind of traditional way of doing it that people are familiar with. So I'm going to talk about that trust concept, that family trust, a living trust, a revocable trust that is active during someone's lifetime. So you've probably all heard the term of a trust, a revocable trust, a living trust. I want you to think about that trust as a bucket. We take that bucket and we plop it right here on this table. And that bucket has rules and instructions as to how that bucket will operate. What will happen during the lifetime of the person that created it, what happens with the assets that are in it, and how it will generally go about distributing assets to beneficiaries, what will happen during the incapacity of a person. And once that bucket's there, created with the rules, we can start taking assets and putting it in there. We can put a house in there, put a checking account in there, we could put investments in there, life insurance in there. And with those rules and instructions on that bucket, that trust, we can now have that operational during your lifetime. So if you become incapacitated, the trustee or the manager of that bucket can now take over management. Upon your death, you don't have to take that will to the courthouse because your assets are in the bucket. So you can take that bucket, or the administrator can, and hand it to the beneficiaries. None of the court's business. It's a smooth transition at death that can avoid that probate process. Does that make sense?
You can, in a way, think of a revocable living trust as a better version of will, where wills have limitations. This revocable living trust has extra provisions and extra safeguards to make sure that the assets that are in the probate, if they were instead in a will, they would go through the probate process, which is the court-monitored process where all your stuff gets distributed after you pass away. With a trust, it doesn't have to go through that process if it's all set up properly.
Does a will depend on, does every will have to be probated? What if you don't have very many assets?
There are some alternatives to going through the probate process. So even if someone created a will, if you have other assets that are below a threshold, you can take some alternative procedures in lieu of probate. So you might not have to go through probate even if you have a will. But I mean, that's kind of an exception. Generally, a probate specifically routes things through probate. A will route it through probate. It's generally what happens. Unless you don't have enough, if you have nothing to administer, then there's nothing to go through probate at all. If you have $7, you can do affidavits and skip it. But generally, a will routes everything right through probate.
In regard to that, if you have most of your assets in payable on deaths or transfer on deaths, and there's very little else left, probate really is something you may have to go through, but there'll be nothing that really happened there much?
Yeah, I mean, there can be. Yeah, it depends on the need for probate. If everything's transferred, if all of your assets are in a trust and have the TODs or PODs, payable on death, transfer on death, or your retirement accounts, qualified accounts, annuities, life insurance, all have beneficiaries, you can avoid probate altogether and never have to deal with that. And that's one of the wonderful things about planning, because every one of you can go down to the courthouse and get all the financial records of everyone who passed away and filed a probate. You can see what debts they had, you can see what assets they had, you can see who they owed money to, where their assets were held. Public information, the moment you file that, you have to give an accounting and a state account to the court. So if you want your information, your private financial information, to remain private upon your death, you need to take action during your lifetime to not make it public through the probate process. Otherwise it does. It becomes public through the administration process.
So you're saying like, yeah, a living trust or a revocable living trust, get either of those in place, that would avoid probate?
Those are the same instrument. People shorten them and use interchangeably the language. If properly funded, if we have that bucket here and we put assets in it, then the assets that are in that can avoid probate, yes. Yep.
What's the time rate on what you put in that bucket? Can you take it out and as long as it's a living one?
Wonderful, yes. So, if I create the bucket, whether it's with my spouse or on my own, during my lifetime, I'm the creator of the bucket. I have the ability to change the rules on the bucket anytime I want. I can put assets in it anytime I want. I can take them out anytime I want. I can change the rules of the bucket anytime I want. I can get rid of the bucket altogether if I want. Anything I want to do with anything in that bucket, I can do during my lifetime. When I die and my spouse dies, a lid gets slapped on that bucket and the terms get locked in. And that's when the provisions kick in for whatever the beneficiaries have.
Yeah, if you put assets into that bucket during your lifetime, is it safe from nursing home?
In the typical revocable living trust, that bucket that I mentioned there, no, those are not protected from the nursing home in any fashion. So what we do if we want that type of protection is we get a separate bucket to set alongside that. And that one, rather than becoming irrevocable upon the death, we make irrevocable right from the get-go. And we set it next to that other bucket and we put a lid on it. And we put assets in there that we want to protect from a lawsuit or a nursing home or creditors or whatever the threat is. And we keep those protected and secure, given the rules that we have to contend with, right? We can't do it today and then go into a nursing home tomorrow. It takes a little bit of pre-planning. But yeah, that's a great question. Yes?
How much pre-planning?
If, it depends. The more that you pre-plan, generally the better, the more you can protect. Ideally, if you can pre-plan 5 years, you can protect the most. But the more you pre-plan, generally the more you can start to protect, or at least position yourself to have more options in the future. So 5 years would be ideal, but it's never too late to start pre-planning.
We have a lot of clients that don't do it 5 years ahead of time, and they wish they would have, for the most part.
Why?
You save a lot more money, for the most part.
Can you be more explicit?
Especially, what?
Can you be more explicit about what you mean?
Yeah, what if it's only in for 4 years? Let's say,
Here's what the rules are. And if you envision it from what it's trying to prevent, if I have $1 million and I'm going to the nursing home this afternoon, and I say, here, son, here's my $1 million. Hi, nursing home, I'm here, I want public benefits. Well, wait a minute. You just give him $1 million, now he's here on the public dole? Right? So if I'm gonna do that, the federal government and the state of Wisconsin says, okay, here's the rules. And it's laid out in black and white, and we can very clearly do it if we follow the set of rules. Okay? So if we have 5 years to pre-plan, what we do is we set up a bucket, put money in it, slap a lid on it, and if we can make it 5 years without applying for public benefits, then the money in that bucket can generally be free and clear, even if the person resides in the nursing home. If we don't make it to 5 years, we have to look at the math and the cost of care versus divestment periods and so forth, and it starts to become complex. But we simply run mathematical formulas to see whether we should pull money out or let the 5-year period run, whatever works out most beneficial. So either way, pre-planning is the key, because it sets the stage for options in the future, even if they don't present themselves.
You're talking about the 5-year look back, right?
Exactly.
And what that means is that we would pay out of pocket up until the point that public benefits kick in. I think that's when you said public benefits. I think that's what you're talking about, but I'm really not sure.
There's different scenarios, and it depends on what you're trying to accomplish and what you're trying to achieve. Because if we have less than 5 years, we do different strategies. That's just one possibility. If we have someone that only has a year or 2 years, then we use some of those instruments in a different fashion to try to maximize and protect savings. And I think that's much beyond the scope of this, because we'll be here till 10 p.m. But you can protect assets using that strategy. You just can't protect as much as if we plan 5 years out. So certainly you should not stop planning just because you don't have 5 years, because you can still, do a lot of things that are wonderfully beneficial. But if you have 5 years, that's where you get the most protection, if your goal is to protect assets in the event of nursing home or other issues that may pop up.
My mother was in a nursing home a few years ago, and there was a 3-year look back. And now it's 5 years. Well, it's going to be 7 years next year.
It was 7 years before, so I don't know how we got to 5. Go ahead.
It's better.
You can move to California, they've got a shorter one. So here's what happens, is that program is a federal program, and so they set the rules, and then the states interpret it. And all the states, you have 50 states interpreting it different. So you have 50 different rules, and then if it gets out of whack, someone will file a lawsuit in the federal government or the Supreme Court, or someone will say, that isn't what they meant, get in line, state. So all the states are different, and at some point, like California, it has a shorter period. You can't, there's some things that can't go longer on or shorter. So yeah, you'll see it vary from state to state, but the general rules are gonna be similar because it's a federal program.
Yeah, I guess stay good. Is there another question right over here?
Is that the same as if you go into an assisted living, or is that something different?
There's some differences there. The assisted living have some wrinkles in that it's a different type of benefit program. but it's similar rules, just a different procedural program. Same issues that you're dealing with. Mhm.
I know, I should get this. If you had money in your bucket of that irretractable, irrevocable trust, I guess, is it a trust or is it?
Yep.
Okay, so it's just the way that it's, whatever's in there, whatever your investments or whatever your money is, it's just the way that that contract is written up to make it for that 5-year period or?
Yeah, so, and that's it. That's exactly what that is. That trust is a contract. It's a contract between you as the person creating it and you or the other person acting as the trustee, right? So you're creating a trust for what happens, a contract for what happens to those assets in that bucket. So once that bucket is created, that we're going to put a